I guess we're getting started here. Welcome, everybody, to our continuing education for the Property Appraiser's Office. It's a program we've been putting out every couple months. We take a different topic and we discuss it, how it relates to your property taxes. So welcome, everybody. And if you have any questions, please be as interactive as you want. Ask any questions. Feel free to interrupt me. We want to, have all the answers for you. If you're online, you can chime in. And I believe, our help in the back will go ahead and give you, ask me your question. So feel free, type them in, ask them, raise your hands, whatever you want to do, please ask away. So today, the presentation we're going to work with is called In the Weeds with Deeds. And so with property taxes, the language of your deed, specifically how it relates to the year-to-year taxes is very important, and we're going to get into that. All right. So we'll hop right into ownership and why that's important for your property taxes. Because what we do from our standpoint is we assess property based on the owners. And so the type of ownership is important as well, but whether you have legal or beneficial title and equity is something that's specifically required for tax exemptions. So for your homestead exemption, for example, you need to have legal or beneficial title and equity as of January 1st to qualify for homestead exemption. If you don't, that's the assessment date. So if you don't have that ownership on January 1st, if you close after that date, you won't qualify for the exemption for the entirety of the year. So for tax exemptions as well, the ownership interest has to be recorded. So in order to claim your homestead exemption, you have to record your deed. So the tenancy type is also going to affect the calculation for your exemptions. We'll get into that in a little bit, but depending on your proportion of your ownership of the property, it's going to change your exemption calculations and your other caps. So recorded instruments, what these are is there's a clerk of the court. So when you purchase a property or something, you sign off on your deed. That's not the end of it. That document has to be put in the kind of the registry of public records, which is through the clerk of the court. And so we base our ownership records off of what's been recorded with the clerk of the court. The process is kind of, they get the deeds recorded with them. A couple weeks later, they'll send us a batch and we make our updates to the tax roll to reflect who the current owners of the property are on the official record. The deed's very important because it is going to tell you, what type of ownership you have, who has the ownership, when the ownership happened, the legal description of the property that you have or the person on the deed has possession of. There's a lot of different types of deeds as well. We're going to kind of break down each of them, but we have a list here of the most common ones. You have your general warranty deed, you have your special warranty deed, your quitclaim deed, corrective instruments, life estates and enhanced life estates, and personal representative deeds. They each are kind of doing the same thing, but a little bit differently. A general warranty deed warrants that the seller or the grantor is the person that owns the property. They have good title and they're giving it to you free and clear of anything. Then special warranty deed is similar. Sometimes they'll have a few different languages in there, but we won't get into that today. A quitclaim deed is a little bit different than a general warranty deed in a way that it is just saying, I am giving you whatever interest I have in the property. It may be no interest. It may be all the interest in the property, but a quitclaim deed isn't warranting to you that I have good title. Corrective instruments, we'll dig into those in a minute too. Those are kind of to correct minor errors on the deed. And your life estates are, ones there you reserve the right to use the property during your lifetime or someone else. And when they pass away, you have a remainderment interest that is the person that immediately takes possession of the property after you pass away or whoever the life tenant is passes away. Personal representative deed, that's something coming out of probate. And that's generally when property is distributed out of probate. When someone dies, they'll do it through a personal representative deed to do that distribution. So these are instruments that are not delivered from the clerk to our office, and they can impact exemptions. So a dissolution of marriage. So we're not going to be provided those. So if you own the property as husband and wife, immediately after the divorce happens, if you own the property as husband and wife, it reverts to a tenancy in common. A tenancy in common means you own it 50-50. So we're not going to know that unless the taxpayer provides us a copy of the dissolution of marriage, even though it is recorded with the clerk of the court. They don't send us those. Corporate entity acquisitions, if you own a business and it gets bought out, we're not going to know that either. Trust documents too. So if you're homesteading a property and it's held in a trust, you're the beneficiary of the trust. You're doing this for estate planning reasons. We don't know you're the beneficiary of the trust. All we know is that there was a deed recorded that put the property into a trust. So we actually have to review those trust documents to figure out if you're qualified to continue a homestead exemption. Probate documents, we don't get those either unless it's a personal representative's deed or a order determining homestead. Nothing else provided to us. So it's important to be proactive when you get these types of documents that may not be provided to the property appraiser. If you can provide them to us, we can make sure we update the tax roll and are able to give you the exemptions or continue the caps on your property that you deserve. So now we'll get into the warranty deed. I touched on that a little bit, but really you're warranting that they are the legal owner of the property, that there's no outstanding, encumbrances, liens, mortgages, or anything on the title. So you're getting it free and clear. The form of the warranty is set by the statutes in Florida, and so they're pretty standard forms. And if it doesn't comply with that, you'll be getting a friendly letter from our office. We have a deeds team who reviews all these. And if something is deficient in your deed, we will generally, if we catch it, we'll reach out to you and say, hey, we noticed this about your deed that you recorded. Did you intend to do this? Because we can't update our records because it's deficient. So quitclaim deed, there's no warranties here. These are usually seen in our office as do-it-yourself deeds where, John Smith to Jane Doe gives all of my property that I own, or gives an address or something. They're not always the most eloquently drafted because they're often do-it-yourself deeds, but these are ones that just give any interest you may have in the property. Corrective instruments, these are instruments that correct a minor error involving the legal description, name, date of an already recorded instrument. So what's different about a corrective instrument is that it runs parallel to the original deed. So any changes you make in a properly executed corrective instrument actually relate back to the instrument that it corrected. So as if it happened when the first deed was recorded. Now, the very important thing about corrective instruments, though, is that you cannot correct tenancy. It's a very common misconception where someone will give away their property on accident to the wrong person or to a son. They meant to do estate planning and they gave away half to their kid instead of doing survivorship rights. You can't just record a corrective instrument and have it relate back and erase what happened. This is very important for exemptions. So if you had 100% homestead exemption on a property and you wanted to do a estate plan and gave it to you and your son or you and your daughter as joint tenants with rights of survivorship, right? Survivorship rights, you can have 100% homestead. Well, if you do it and forget to put survivorship, the default tenancy in Florida is tenancy in common, which means 50-50 ownership or, however many people own the property. Well, if you have a homestead, that just cut your homestead in half because you forgot to include that survivorship language. And a corrective instrument isn't going to put it back on because it cannot retroactively change that tenancy. So it's something to be wary of. Now, there is a way to retroactively alter deeds, but you can't do it through the corrective deed. It's got to be done by the courts. And so this is something that we've seen a lot more common recently when someone inadvertently makes a change to a deed that causes them to lose a portion of their homestead exemption, what we've seen are these deed reformation actions come through. We've had probably four or five of them in the past year and a half, and essentially they've all been the same situation. They meant to add someone on with survivorship rights, and they didn't. They lost 50% of their exemption or more because it went beyond the assessment date. The assessment date in Florida is January 1st. We look at everything as of January 1st. That's a very important date. That's when we value your property. That's when we determine if you qualify for exemptions. So if you inadvertently record a deed that changes the tenancy and you lose half your homestead, if you don't fix it before January 1st, there's nothing we can do to put it on retroactively. However, so some clever minds out there have gone to court and had a judge review it and say there was a mutual mistake of fact. And because, you know, myself and my son, we didn't mean to do it this way. What we had intended to do was do survivorship rights. And what they have is the court alters that. And then once that court order is issued, we can actually retroactively put the homestead back on at 100% and grant you a refund for the extra taxes you paid based off of the lost exemption. Yes, absolutely.
Action.
So your question is you were a resident of Minnesota, you came to Florida, and when did you own the property? Oh, so you've owned it 8 years and you still own the property.
Yes.
And you just recently changed your residency
Yes.
to here.
Tax exemption.
So, well, to better answer your question, I'm probably going to need to look at your property and the deed and everything. So after the presentation, if you can give me your information, I can call you and reach out and we can discuss that, because without actually looking at the deed and the survivorship and your occupancy date and everything else, I'm not going to be able to give you an answer on the spot. But that, you know, that's the importance of I'm glad you're asking that question, because these are, you know, things you do need to occupy the property and be a Florida resident to get the homestead exemption. Now, when you did that, when you actually started moving here, those are all questions that we look at, because the residency is a fact-based question. Ownership is a legal issue. So what we would do for yours is we're going to look at all the facts surrounding when you became a permanent resident to determine if you qualify for homestead this year or next year in 2024, because that's a fact analysis versus the ownership, which is you own the property for 8 years. There's no issue there. We know you own the property as of January 1st. It's a residency question that we would get into that requires us to look at the facts surrounding it. So that's why we'll have you reach back out to us and or leave your info, and I'll reach out to you, you know, tomorrow or Monday whenever I'm in the office. So thank you. And I'm sorry if I didn't answer it directly on the spot, but I will have an answer for you. Yes. So yes, for the corrective legal action, the reformations, they've become a thing lately. So if you do end up inadvertently removing a portion, it's not the end of the world. There are ways to address that. Just you know, you have to do it through the right legal avenue. And so we always recommend seeking out an attorney if you do want to take this type of action, because it could also cause other issues unrelated to your property taxes. So there are a lot of different types of tenancy, as we've been discussing with the survivorship and everything. So here are, you know, as a non-exhaustive list, you got your common one, which is your fee simple sole ownership. You've got your tenants in common, which is the default when there are multiple owners of a property on a deed and it does not refer to any tenancy. It's presumed that you all own the property in equal shares. Also, tenancy in common, you can, on the face of the deed, separate who owns how much percentage. I mean, we've seen ones where there's a tenancy in common where one person had a 0.0001% interest and the other person had the 99.9999 interest. Joint tenants with rights to survivorship. This is a very important one because it's very common. It is where multiple owners own the property jointly. And if one of them passes away, their interest immediately transfers to the other joint tenants of the rights to survivorship who are on the property. This is important for homestead because it's owned jointly. Each joint tenant is entitled to 100% of the homestead exemption on the property. Now, per residential unit, which would be, your homes, you're only allowed to have one full homestead exemption. So if you have 3 joint tenants, all homesteading the same one single family home, you would still only get the 50,000, or exemption, homestead exemption. But in the event one of them passed away, then the Save Our Homes cap, which is that cap on the assessment increase each year that limits it to 3% of the CPI, whichever is lower. If there's multiple joint tenants with homestead, if one of them passes away, the property doesn't get reassessed back to market value. Tenancy by the entireties is the exact same thing as joint tenants with the rights to survivorship, except it's for married couples. It's just got a different name. You've got your ownership and trust. This is where you basically separate the type of ownership, where the trustee of the trust holds legal title to the real estate or whatever property is in the trust, and administers it pursuant to some type of underlying agreement that's not usually recorded in public records. The beneficiary of the trust has the beneficial interest in the property, whether it be real estate or other assets in it. And so for this one, the legal title as the trustee always qualifies for homestead exemption because they have legal title. Now, the beneficiary of a trust can sometimes qualify for homestead. They have to have what's known as beneficial title in equity to the real property. So under the trust agreement, it has to say a little bit more than they're the beneficiary. It needs to say that they can reside on the real property or that they have the right to occupy the real property. They have to have some type of interest to the actual dirt under the trust agreement to be able to homestead it. Then you've got your life estate. That is where you retain the use of the property and ownership of the property for your lifetime. And when you pass away, on the face of the deed, there's generally a named remainderman who the property will go to in the event that you pass away. It's a little bit different than the joint tenants with rights to survivorship because the remainder doesn't have any interest in the property until you pass away. It's considered a future interest in the property. And then you can have a combination of all the different types of ownerships. You can have, 50% in a tenancy in common, and then you can have another half of the property owned as joint tenancy. You can mix and match. So tenancy common, as we discussed, this is where you own it in different percentages, and it's the default in Florida. For homestead purposes, you can claim homestead proportionate to your interest in the property. So 50-50, you get 50% homestead exemption. The other 50% gets the non-homestead 10% cap on the property. And for any other ratios that you own the property at. Joint tenants with rights to survivorship, as we discussed, this is the joint ownership of the property. You all have technically 100% ownership interest, which means that all of you can claim 100% homestead exemption on the property. And if one person dies, it immediately goes to the others. An important kind of caveat of joint tenants' rights survivorship is that if a joint tenant sells their interest, their proportionate interest becomes a tenancy in common. So if you have 3 joint tenants with rights survivorship, one of them decides, I want out of this, I'm selling my interest. Well, now there's 3 of you, so they have a 33% interest that they're effectively selling and severing that joint tenancy with rights of survivorship at that time. So you do not, and the question was, a person put their property into a trust, do they need to apply for homestead exemption again? The answer is no. However, if you are the beneficiary of the trust and are the homestead applicant or homestead beneficiary, I should say, then you will need to provide us a copy of your trust so we can make sure, as I was talking about earlier, that you maintain an equitable interest in the real estate. If you're the trustee of the trust, you don't need to take any action because as the trustee, you automatically qualify for homestead. And so feel free to follow up if you have any other questions. So we'll move right into tenancy by entireties. Like I said, this is the one for marriages, acts the same way as survivorship rights. The important distinction here is that in the event of a divorce, it immediately reverts to tenancy in common. What this means for your homestead is a little bit complicated. I don't know that we're going to fully get into it here, but there is a form So when you've been married for a long time and you've been lived at the marital home for a long time, you can accrue a very large Save Our Homes cap. Well, when you get divorced, you go to tenants in common, and generally, divorced couples don't stay in the marital home together. One of them may end up getting it through the divorce decree. Who knows what they do, or they might sell it. Well, if you want to use that Save Our Homes cap as an asset or anything along those lines, there is a form from the Department of Revenue called a 501TS form. This allows divorced couples to decide what percentage of that Save Our Homes cap they want to each take. So, you can do it as just a simple 50-50 split, which is presumed if no TS form is given to us, or they can designate it other ways. One spouse could take 80% of the Save Our Homes cap, and the other could take 20 to their new home, or vice versa. So now we're going to get into trust and homestead. It's just we just had that question on. Oh, come on in. Okay. So for trusts and homestead, they're used for a variety of purposes. We had a lost customer here, but they're used for various estate planning purposes. As we discussed earlier, what they do is they essentially separate the title, where the trustee has the legal title and the underlying beneficial interest lies in the beneficiary of the trust. As we just talked about, the trustee always can claim homestead, and the beneficiary sometimes. Usually, the trustee retains the right to do whatever they want with the property to properly care for it because they're entrusted with that. Trust terminology is very important when when reviewing these. So the trust itself is the underlying agreement where the property goes. The settlor of the trust is the person that creates the trust, or the person putting assets into the trust. The trustee is the one with the legal title and manages the property within the trust. The beneficiary are the ones that hold the beneficial interest to the actual property that was placed in the trust. And then below we get into, these aren't necessarily trust terms, but a life tenant, if you heard us talk about that with the life estates, is the person that is the measuring life. So, if you have a life estate, then the measuring life is the life tenant of that, and the remainder men are who it passes to when they die. So we'll get into the homestead exemption. These are the criteria for a beneficiary of a trust to claim homestead exemption. Their interest must be real property, not personal property. So that's a question we get asked a lot, is what's the difference between real and personal property? Well, personal property is income. It's the cash that comes from the house. So if you're entitled to the proceeds of the property, then that just means you can get any money the property produces, but you don't actually have an interest in the home itself or the real estate itself, the land. You just have an interest in what it produces, the money that it gives you. So for homestead, you have to have a real property interest, not personal property. You have to have the right to live there, and it has to be present possessory, which means it has to be now. You have to be able to live there now, not 6 years from now, not when someone dies. You have to be able to live there now to get homestead as a beneficiary. And then also the deed placing the property into the trust needs to be recorded. So here is just kind of what we've taken is from all the trust documents we've reviewed and everything. This is just kind of some sample language of one that we like to see in trusts because it makes our job easy to when we review a trust to see if a beneficiary qualifies for homestead. This is a nice one. This comes straight from the face of the recorded deed itself. So the grantor here put the property into a trust, right? Their own trust that they were a beneficiary of. So what they did is they said, me putting the property into the trust, I'm the grantor, I am reserving the right to reside on the real property and make it my permanent residence. And then further, they added in there, it's my intent that I have the beneficial interest and possessory right to the real estate, not the personal property, the real estate. And so when we see ones like this, Very easy. We don't have to do anything, any further review. We can just continue the homestead exemption or approve the homestead exemption application. So for life estates, there's a couple different kinds of life estates that I'll discuss because you may have heard this word before, called a ladybird deed, thrown out there. So a ladybird deed is a life estate with an asterisk next to it, basically. What it means is that you're creating a regular life estate where for my lifetime, if it's my life estate, I can live there. When I die, it goes to whoever I designated. Well, the ladybird deed is a little bit different in a way that I can change who my property goes to at any time before I die. And whoever the last one is who I designated the remainderment to when I die, that's who it goes to. And it's another thing, like I said, if you're looking into estate planning, these are pretty common, but as always, talk to your attorneys, talk to your estate planners, whoever you have before deciding what to do. But yeah, for here, it's life estate. Once it ends, goes to the remainderment. If there's no remainderment named, actually, it goes back to who the grantor was. It reverts. Just kind of a fun one. And and an important thing down here in the bold is that you as the life estate holder, you always qualify for homestead exemption because you have the right to use the property during your lifetime. And here's kind of the difference here. So the ladybird deed is also called an enhanced life estate. That's another name for it. But you can see here, reserving unto himself a life estate, as to a life estate. Those are just the general deed terms you'll see to know it's a life estate. Now, the enhanced life estate's a little bit different, as in it says, I have it for my life, but I can sell or convey it without the joinder of the remainderment, which means that at any point in time, I can still sell my property without the remainderment having to sign off on it. Because if it doesn't have that language, you as the remainderment actually have an interest in the property. So the person who holds the life estate can't necessarily sell it outright. Yes. Possibly, but they could only mortgage their interest, really. So I'm not sure who would want to do that, but. So now we're going to get into another one. It's a kind of a big issue for our office, which is the Save Our Homes cap and the 10% non-homestead cap, and when they get removed from properties, which we call a cap reset. Your Save Our Homes cap is being reset to the market value. Your 10% cap is being reset to the market value. So the Save Our Homes cap was a 92 constitutional amendment from Lee County. And what it did is it limits the increase in your assessed value to 3% or the CPI, whichever is lower each year. This is important because if we're in a rising market, your market value may go way up, but because your assessed value can only go up 3% or the CPI, then your taxes are going to be much lower. And this is a big reason why you'll see some houses that may have been owned for 20, 30 years have a significantly lower tax rate than recently purchased homes. And the reasoning behind the Save Our Homes cap was it was put in place to kind of stop people from being taxed out of their homes if the market continued to rise in their area. So the non-homestead cap is a newer provision. This was in 2008. And what it does is for all other property that doesn't have a homestead exemption, they're limited to a 10% cap or 10% increase, in assessed value each year. This does not affect the school millage rates, though, so that they still go up to market value. The cap resets upon an ownership change or homestead being applied for. So the 10% cap does not stay on there forever. If you apply for homestead exemption, you can only get one cap or the other. You're either homestead cap or non-homestead cap. So recently, with the market going up a little bit, we've actually been seeing situations where you'll get an increase in taxes when someone applies for homestead for the first time, because they may have owned a property and it may have been a vacation home while they're living somewhere else. They decide to move down here, move into the home and homestead it. and they've accrued a significant 10% cap. Well, that 10% cap goes away and you get the homestead exemption. Sometimes it can actually increase your taxes on the property. And it's important if that ends up happening, you can contact our office. We actually will, you can rescind your homestead application. If you do that and your taxes go way up, you can let us know by the end of the year. Actually, I don't want to homestead it, keep the 10% cap on, and we'll do that. Another thing too is for the caps, new construction gets added over those. So if you make an addition to your home, that's actually not going to be covered by your Save Our Homes cap or the 10% cap. Now, if it's simply maintenance to the home, it's not going to. But if you make an addition to it and add on a wing to the house or something, that is going to go over your cap. And so here, this is kind of just a chart here showing what the CPI was versus the cap. So if you look since 2010, the CPI has gone over 3% once. And then come 22 and 23, the CPI, which is based off inflation, has been significantly higher than 3%. So we've been going up that 3%, which is the lower one. Consumer Price Index. And I'm not sure who publishes that. Can't remember off the top of my head, but. So here's the cap comparison. So the Save Our Homes, which is tied to your homestead, and the non-homestead 10% cap. The most glaring difference is 10% versus the 3% or lower. That your assessed value can go up each year. But the biggest thing is that you can transfer your Save Our Homes cap. If you have a homestead on a property and you've owned it for some time and you decide to move to a new home, you can take that tax deferment, the Save Our Homes cap, and move it to the new home you're going to within 3 years. Okay, and the Bureau of Labor publishes the CPI each year. So here are some exceptions to when the cap resets. So the cap resets when there's a transfer of ownership. That's the big one. But there are certain situations where even if there is a transfer or change of ownership, it does not reset the cap. So they're almost identical between the non-homestead and Save Our Homes, except the non-homestead cap makes a couple differences when there's transfers related to corporate entities. But for the Save Our Homes cap, if you transfer something to correct an error, like change, you record a deed to fix the legal description if it was wrong, or something was off on the deed and you correct that, then it will not reset your cap. Transfer between legal and equitable title. This was the trust that we're talking about. So when you place property into a trust, you're splitting legal and equitable title between the beneficiary and the trustee. So when that happens, that does not reset your Save Our Homes cap or the non-homestead 10% cap. Transfer between a husband and wife does not reset the caps. Creation of a 99-year lease is as long as you're the lessee. So if I put my property into an LLC and the LLC leases it back to me for 99 years, that's not going to reset it, because a 98 or greater year lease is considered having equitable title to the property. And then through an operation of law to the surviving spouse or minor children, which means if someone passes away and their minor child gets the house, that's not going to reset the cap. Or if someone passes away and it goes to the surviving spouse, it's not going to reset the cap. And it also transfers to dependents as well, as long as they're actually declared a dependent, not just claimed on your IRS. It has to be more than just an income dependent. Generally, if you have like guardianship or something over a person that's been declared, dependent, then it doesn't count as a transfer. Then for the non-homestead, the big difference, because those private properties that may not qualify for homestead, one of the exceptions is the cumulative transfer of more than 50% of the ownership of the entity that owns it through a public exchange. This is really just for your properties that are bought and sold, stock wise. If some underlying entity buys it out, it's not gonna reset the cap. So recently, there was a case about the 10% cap reset. So this deals primarily with investment properties. We used to see this issue a lot more. We're glad to have a case on it now. But essentially, what happened was people would place their property into an LLC to protect their liability. They may have owned the property for some time. Well, an LLC, by virtue of its nature, is separate than its members. So when I put my property into an LLC, it resets the 10% cap because I don't own the property, the LLC owns the property. Even though I may be the sole owner of the LLC and I pay taxes on that LLC, federally through income, technically I'm not the direct owner of the real estate, the LLC is. And so it's considered a transfer and the cap is removed. And then recently we had this case come out in 2023 that basically, summarized what I just said and held that that is the case. An LLC is not, even though it may act as a pass-through for federal taxes, it's one step removed from the actual owner. So it does reassess the property when it transfers into or out of an LLC. So marriages and a homestead. Family unit. It is something in the Constitution, and it didn't get defined for quite some time until the courts did it. So one homestead exemption per one family unit. Well, what's a family unit? Well, the courts have said it is a married couple. So what this means is if you and your spouse each have your own homesteads, you can't do that. One of you's got to give it up. This is what we see a lot of times when you see marriages, a little later in life, where each person is established, has owned property, has homesteads. Well, when you get married, you got to give one up because a family unit is only entitled to one homestead, except for in rare situations where they're separated and they have no financial or emotional connections. Now, I don't know how we're supposed to determine if a married couple has an emotional connection, but that's what the courts say we're supposed to do. So what we rely on more heavily is the financial connection. So if two people are married and they're getting separated, what we do is we actually have a form to fill out that determines if you have financial connections, and if you don't, if everything's separate, you're filing separately, then you can qualify for 2 exemptions while married. So we're going to get into exemptions from public records. There's a couple different types. So there are, in Florida, we have 2 kind of types of confidential documents. You have exempt documents and you have confidential documents. Confidential are your social security numbers, anything you provide us that's considered a return, which means like income information related to your property, sales verification surveys that our office sends out, homestead exemptions, all of their application, anything supporting your homestead exemption, those are confidential from the records. And we cannot release those except to you or your authorized representative. Now, an exemption from public record are your protected names. There's some other exempt records as well, but for our office's purpose, this is what's important. So if you are a person, this is a non-exhaustive list, there's a lot of them, and they're all available on our website, but you can have your name redacted from public records because as it is right now, everybody is searchable on public records if you own property. But if you have if you're a victim of violent crime or any of these other classes of people, most of them are related to government agencies that deal with sensitive information or do sensitive work, then you can have your name protected from our records. To do this, you have to make the request in writing. We have a form to make it easier that has, this is my qualifying profession, and so, but you also can just provide us something in writing, but we may need additional info. It's a lot easier to just do it through the website. Now, another thing is this protects your name. It doesn't protect your address. So if someone looks up your address and you're one of these protected people, they'll still see it exists in the records, but they won't know who owns it. And so you can see in here, and these are all the data that gets removed from our records, and that's what it looks like if you are protected. You'll see the owner name is asterisk, the book and page of their recorded deed, so you can't go to the clerk of the court's website and look at the deed. Any elevation certificate, permits, and other information that would show their name in public records is all exempted out. Now, there are a couple exceptions to this. Any attorney who's in good standing can request that info, or title insurance agents and insurance agencies can also request that info. And they have to sign and notarize a form submitted to our office to do that. So I'll hop into some recent legislation. So if you are a widow, widower, blind, or totally and permanently disabled, the exemption used to be $500 off of your assessed value. So what that meant is you got about $8 to $12 off your taxes for that exemption. They increased it to $5,000, which comes up closer to $80 to $120. So a little bit better. So another one that's come up with all the storm damage is a tax abatement, which is a refund essentially for homes rendered uninhabitable by a catastrophic event. With Idalia, this has kind of been an important one, but if your house is destroyed, or not even destroyed, just rendered uninhabitable by the event for greater than 30 days, you can provide us evidence of that and apply through a DR 465 form, and our office has it available, and you get a refund for the amount of days you were unable to occupy the property because of the damage. So if you get a bunch of flooding due to the hurricane, you're out of your house for 90 days trying to get it all sorted out and repaired. Those 90 days, you'll be refunded that amount back the next year. Now, preventive maintenance, this is the condominium one, the collapse. This went into effect a couple of years ago. And so now you have to have your milestone inspections done, and the structural integrity reserve every 10 years to make sure it's actually funded. This is why recently we've been seeing some big assessments on certain condominiums. But the reason behind that is this, to make sure there's enough in those reserves and these properties are being inspected, regularly. The next one, the tax package. So there's no more levying special assessments on agricultural lands. It has a minor effect in Pinellas because we have maybe 90 parcels to 100 parcels that get an agricultural classification here. There's just not enough land for it. The one below is a little bit more interesting. So the TMP disabled veteran exemption or surviving spouse. This one removed the requirement that they had to have had the exemption already in place to get the prorated refund. So they changed the law a few years back where if you're a veteran and you buy a property mid-year, you didn't have to pay taxes for the days that you acquired the property because you're fully exempt. So you would get a prorated refund back the next year in the taxes. And then the other one is this was more of a cleanup. There was already a court case that removed the requirement that a veteran be a resident on the state, resident of the state on January 1st of the year they died. They codified that into statute, but it was already the law based on a court case that came out in 2020. The definition of first responder was revised to include federal law enforcement and expands the exemption for surviving spouses of those that died in the line of duty. There was another one that's more of it's a niche, I would say, change because it really affects nothing in Pinellas that I'm aware of, but the educational, properties used for educational purposes are deemed owned by that. If they're the lessee that owns the leasehold interest in a bona fide lease for a nominal amount, when the original lease is 98 years or more. This is more about that equitable ownership, where if you have a 98 or greater year lease, you have equitable ownership. They kind of codified this, but it doesn't have a significant impact on anything, at least here. And then they also, if land buildings and other improvements used exclusively for educational purposes are deemed owned by them, if it received the exemption on the same property for any of the 10 consecutive prior years. And then also at the bottom, they did make a change in the tax packet here related to that catastrophic event exemption. The original language had some weird calculations you had to do based on the value of the home. They just took that out. So now it's completely proportionate. However many days you were displaced over 30 days, you get that refund. So this is the current one here. And so right now, there is a disclosure of ad valorem taxes to prospective purchaser bill proposed, championed by the man behind you, actually, Mr. Twitty. And what this is a bill to get selling platforms in Florida to accurately reflect the taxes. Because a lot of times they're just going to put the seller's taxes on there. And when you buy a home and you rely on the seller's taxes, as we talked about earlier, you've got those homestead exemptions that can stay on a property for a long time and keep the taxes low. If a real estate website is showing the seller's taxes, when you buy, they may go up 500, 600% because the person that before had owned it since 1994. So what's been proposed in this bill is to get a fair and accurate estimate of the buyer's taxes if they were to purchase the home. And so, we're working with the Department of Revenue to kind of build a database. We have an estimator here, and kind of what the bill would do would be require those sites to at least either accurately reflect the taxes or link them to a property appraiser's estimator of the buyer's taxes. Now, if you haven't seen it yet, we do have a new website. It is .gov now. We are no longer .org, so we're officially a government. We've got our heavy users, but it's actually quite nice now. The new website has some really, really great features. We've got the large map where you can click on any parcel and get kind of a brief outline of it. It's really, really great. You can see just about anything related to property here. You can see your flood zones, if a property has an elevation certificate. It's really awesome, and I encourage everybody to at least play around with it if you haven't been on the new website yet. Does that one go? Oh, okay. Yeah, you can go on it. So website stats real quick. We get 1.6 million users and 5.3 million sessions in 22. So a lot of people use our website, and it's great. We're really happy. So, and because of those high numbers, we want to make sure that it works well and you can see everything you want on there. So this is the tax estimator that we were talking about briefly when the proposed legislation. So on our website, if you're looking at purchasing a property, you can go to Tool Forms and Data and click on the tax estimator. This will bring you to this screen. So what you do is you type in the address of what you're thinking about purchasing, the purchase year, and the estimated property purchase price. Then you also can calculate your portability and homestead exemption if you plan on living there. It's wonderful. So if you were to click on the portability one, it'll ask you to type in the property. If it's another Pinellas property, you can actually type in the Pinellas property and it'll pull the Save Our Homes cap you have from that one and apply it to the new home that you're trying to purchase or thinking about purchasing to make the estimate as close as possible. And then it'll pull up this page, which is the actual estimate here. And it'll tell you, your estimated ad valorem taxes, your estimated assessed value, and if it has any non-ad valorem taxes, if you're in a surface water district or something, it'll tell you all that. It's a really great tool. And then here we've got a whole lot of a lot of flyers here. If you're a buyer, seller, homesteader, veteran, if you need any type of information about that, or if you want to take any of those, we have a bunch of them sitting around just around the corner in the office. Feel free to take them. And I don't think we have the fraud alert on here, but another important tool actually through the clerk of the court is they offer a free fraud alert service. We always, encourage people to use that. What it is, you sign up for it, and if anyone records anything with your name on it, you'll get pinged. They'll send you an email or they'll contact you in whatever way to tell you that something's been recorded. It's a great service to get. But thank you so much for coming here today. I really appreciate you. And, everything on here is our social media. Please follow us. We just want to be able to educate the public as much as possible. And I really appreciate it. And thank you for coming.